Good evening, respected members and my dear friends. A very interesting judgment from the Honorable Tripura High Court in a recent past, reported in Taxman 182, taxman.com 144, Sahil Enterprises versus Union of India, judgment from the Chief Justice bench from Honorable Tripura High Court. The gist of the judgment is though Section 16(2)(c) of the CGST Act is not violative of Constitution of India, it should be read down and applied only where transaction is found to be non-bona fide or is a collusive, fraudulent, etc. Where transaction between purchasing dealer and supplier was bona fide and purchasing dealer paid GST to supplier, but supplier failed to deposit same with government. ITC could not be denied to the purchasing dealer. This is the gist of the judgment. So, Tripura High Court categorically held that it is not violative of the Constitution of India. It is within the ambit of the Constitution of India. But Section 16(2)(c), the other meaning of the Section 16(2)(c) is it is impossible for purchaser to check whether supplier had deposited tax paid by him to government and then avail ITC. This is the very important finding from the Honorable High Court. It is impossible for purchaser to check whether supplier had deposited tax paid by him to government and then avail the IT input tax credit. This is one of the important finding. And the second thing is purchasing dealer cannot be asked to do impossible. So he cannot go to the selling dealer's place and inquire whether the selling dealer is a genuine dealer or not, and inquire the bona fides and get the credentials, and then to do business with the selling dealer, whether the selling dealer will pay the tax paid by the purchasing dealer to the selling dealer, and then only he can be in a position to avail the input tax credit. These things are very impossible. So purchase dealer cannot be asked to do impossible things. This is the final finding from the Honorable High Court of Tripura. So only selling dealer, if any fraudulent activity find out between the purchasing dealer and the selling dealer, if any collusion between the purchasing dealer and selling dealer, then only 16(2)(c) will be invoked, or otherwise if the transaction prima facie found to be bona fide, found to be genuine, and found to be the purchasing dealer is a bona fide purchaser, then all transaction in this category should be allowed and input tax credit cannot be denied. This is the gist of the judgment and conclusion of the Honorable High Court of Tripura in the case of Sahil Enterprise versus Union of India. The ultimate signal from the Honorable Tripura High Court is purchasing dealer cannot be asked to do impossible things. That is, identify a selling dealer whether he is correct or not, whether he can deposit or not, whether the selling dealer credentials are correct or not. He will deposit the government at a later date after the transaction is completed and receive the money from the purchasing dealer. These are all the impossible tasks to be conducted by the purchasing dealer, though it is not violative of Article 14, 19, 1G, 265, 300A, etc. But it is to be invoked in only a rarest of the rare cases. Kindly go through the judgment and frame your opinion accordingly and advise your clients accordingly. Please like, share, and subscribe my channel. Thank you. Thank you very much.